Good morning, my little Brooksaholics. How are we doing? Are you ready for updates? Let me put this up in the... so we don't miss anything. I'm going to put that right up there. Waiting for them to come on. Yeah, so the new attorney's name is Russell Jones. And the court website has not really updated that yet, but let's see. We're good on the audio. Everybody can hear me okay. It's good to see everybody. How are we? Love the song, never heard it. It's called Let It Snow by Wildson, Wildson. I get it off of Epidemic Sound. I'm just kind of scrolling through the chat here. You guys are like popping off in the chat. Welcome in, everybody. Great to see you all. I appreciate you being here. Just a reminder for those of you who are members, we're having our little recipe giveaway live stream tonight at 7 o'clock. So be there or be square. And also, do any of us have jobs? Lenny. Carrie says, come, we're gonna come. Lenny says, Carrie says, come, we're gonna come. So all I got to say is her to be here. She gonna be here. Good gracious alive. Trying to be slick. Lenny's trying to be slick this morning. Come on, man. What y'all trying to do? It's 4 against 1. Oh, you've never been on a live when it first started? Mishmash. Mishmash. Mary sings that intro. You had Merry Christmas, baby. Love it. Oh, Carrie who sings it. I just put it up. I put it in the chat. Let It Snow by Wildson. Good morning, Miss Noreen. You ain't got to worry about that, Carrie. Because if I say come, they go come. Kimmy. You guys did get an email notification. That's good. Yeah, I stopped putting notifications on my shorts, and I'm thinking it might help with, I think you're limited to the number of notifications as a creator that you can put out, I believe. And so that might be part of the problem. I was part of the problem and I didn't know it. Don't tell anybody. I hope he's allowed to represent himself. He's not going to be RJ Supreme. He is not going to be. They've got a new attorney already set up for him. And if they show it, we will be there. We're going to open all the doors today, Noreen. Opening all them doors. All right, guys. The last time we sat here and did this, we sat here and waited and waited and waited. And nothing ever came up. So I've got a couple of different court streams pulled up in the background. So that because sometimes I just check to see if their streams are, working for the day or whatever. So I do have that up. Now, while I'm going to be running we're going to watch the verdict watch day, which was day 14. So we'll watch that in the background while we wait for this. And then if it comes on, if they bring him a Zoom call or whatever it is that they're supposed to do, then we'll change over to that. Okay. So here's your entertainment until then. Oh, by the way, I'm having allergy issues today, you guys. So I apologize if I sound very nasally. I think it's because I got the heater on. I've been sneezing my head off. All right, let's do this.
And 14th Amendment due process rights. I make a reservation for those rights, especially, but all rights at this time.
The record to reflect that the individual known to this court as Darrell Brooks is present in person in custody He is appearing today in street clothes. He has a dress shirt and a tie on. He's also wearing a mask.
And I don't consent to being called that name for the record. As this paperwork I accept for value in return for value, as it does not state the correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Your objection is noted. It's baseless in law and fact, and that is simply a caption on a pleading
That
on
is not my
the
name.
final jury instructions.
That is not my name, for the record.
All right,
I
the
don't
record should
recognize that
reflect,
name or-
Mr. Brooks, I'm talking. The record
I
should
don't.
reflect that at 3:23 PM yesterday, all of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court will be reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first 73 pages this morning. I do anticipate having to take one or two breaks before I complete all of that. My plan is to do that and then take the lunch break. And then when we come back from lunch, to have the parties provide they're not opening, their closing arguments. And then following the closing arguments, the court has the final jury instructions, which go through the closing instruction, instructions 460, 484, and all of the verdicts. And then the instruction to the jury 515 about their verdicts needing to be unanimous, and then selection of a presiding juror. The very last page, 107, actually is not read until the close of the case and only following receipt of verdicts or.
Really quickly, I wanted to show you guys something because everybody always asks me about the appeal. So I wanted to show you guys this. So, according to the state of Wisconsin website, Supreme Court and Court of Appeals access, the last activity on this was on July the 14th. And it basically was just, it is ordered that the time for filing the transcripts in this case is extended to November the 18th. So at this point, and I'm sure most of you guys know this, but at this point, the transcripts should be at the appeals attorney's office. The appeal attorney is Michael Covey, representing the defendant, Darrell Eugene Brooks. Looks like they actually they had to extend the transcripts. Let's see, 1, 2, 3, several times. Bless their hearts. Those poor court reporters. Bless their hearts. So as far as we know, they have been sent in because there has not been another extension on this. Of course, it could be that this just hasn't been updated, but I did want to show you guys that. So we're just waiting to hear. We'll see what happens. I mean, all you can do. You thought his middle name was Edward? I hope not. On the website, let's see. Look, let me show you this. It says also known as Darrell Eugene Brooks, but maybe, and then up at the top it says Darrell Edward Brooks Jr. So yeah, You're probably right. Can I just call him Eugene anyway? I really liked that. I liked Eugene. When we're looking at what's going on, basically, the last update was on November 30th of 2023, where they had said, okay, get the public defender assigned because, last time we were here, they went into court. They didn't show it, but they went into court and they were like, we haven't assigned him an attorney yet, a new attorney yet. Okay, yeah, it's Edward. Okay, whatever, Sean. I'm just kidding, Sean. But I like Eugene. Don't y'all like Eugene? Well, whatever. But it is Edward. What was I saying? Because my ADD kicked in. Okay. So apparently nothing has been updated on the court dockets, but he has been assigned Mr. Russell Jones as his attorney. So we will see what's going on. So again, if they show it, we'll be there. Until then, enjoy this coverage by our sponsor, the Deebrook School of Law.
Is received. So page 107 is not something that will be read today. As indicated yesterday, I will be selecting the alternates by random selection. We'll use the tumbler and select 3 numbers out of that, but that will be done after all of the instructions are read and the parties have an opportunity to give their closing arguments.
Your Honor, accept for value and return for value any documents that you just alluded to. I've not seen them.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can. The court retrieved the final jury instructions. I personally didn't. I had someone do it, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought out a little bit later.
There was a conference. We talking about the proceedings from yesterday, or after you had told us we recessed?
Mr. Brooks?
I'm referring to after you called recess for the night yesterday. That's what I'm referring to. I was put in the holding cell for over an hour because they said it was some paperwork that needed to be.
That is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties. So that's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
Left them in what holding cell? In here?
I have to look through his paperwork to see if they're on here.
What holding cell are you referring to, Your Honor?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts?
Yeah.
All right, he has those. Thank you.
Is this the paperwork that was just put on it was paperwork on the desk when I came in. That was on top of my folders.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know. But they are also on your desk now.
I accept for value and return for value any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over an hour?
There was no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork based upon the discussion that was held on the record in open court yesterday.
I was told that I had to stay there per you.
Yes, so that we could provide them to you and you would have an opportunity to take them back to your cell.
But can they have been delivered to the jail?
All right. I don't believe there's any other preliminary issues we
There are.
need to address other than an advisement I will have for Mr. Brooks. But let me turn to the parties and ask if there's anything preliminary to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state.
No, Your Honor, thank you.
All right. Anything else from you, sir?
Yes, there is. Yesterday, I stressed to the court numerous times about me not understanding the proceedings, and essentially how decisions are being made on my behalf without my understanding or giving consent.
The court made various rulings yesterday. I made findings and ultimately made some determinations. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions were made when I was not present in the courtroom. I was in the other courtroom,
That
correct?
is true, sir.
Is that correct?
The record will indicate when those were made and where you were.
I can't see the record though. How am I supposed to know what the record will reflect?
Sir, the decisions were made yesterday. I'm not revisiting them today.
They need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record. I'm still trying to understand, Your Honor, how you made a judicial determination on my behalf, which I did not give consent to, as you say, I forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to, but that decision was made for me. Also, the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I was ready to rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights. I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer. But I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand fundamentally? It's not me saying yes or no. And it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that.
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah. There was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side.
Oh, yeah, he's got a lot of people that want to speak for him,
If
doesn't
it
he?
pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think
If
that's a
that
fair
pleases-
request, sir.
If that pleases.
I think that's a fair request. I thought about that and some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone. if there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st with kind of a proposed plan of how many people do you think will speak on your behalf? How long do you think it will take? So that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request.
Why y'all giving Darrell such a hard
you.
time? He's a grown man with grown
Right.
kids.
So with all of that then, sir, subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record.
His affairs, he's got to get his
to the
tent.
extent that you are asking me to reconsider any
He's
of
got to
that,
put his tent
that's
up.
how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be, that's still not, I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence, nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them. And to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir.
How did
What
I
I will tell
forfeit?
you is this.
How did I forfeit
This
the
jury is
opportunity
here.
to be able to place into evidence?
Mr. Brooks, I'm
that
not
need
going to
be-
debate this further.
I'm not trying to debate. I'm
you
trying to understand.
to respect the fact that I've made rulings.
Your Honor, that's you
It's
made
not
a
my
judicial
job to
determination.
explain them
You made
to
it.
you.
I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things into evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion is not being able to place those things into the record. Things
Mr.
that
Brooks, I'm
things
gonna
that
cut you off
clearly help my
because
defense.
I
Clearly.
stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record, your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the
Mr.
record?
Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks,
I'm
I'm
just,
no longer
I'm
going
just
to
seeking
talk
to
about
understand.
this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or
The
evidence
filings
or
that I
the
filed.
rulings or
I'm
the
asking a
law
question,
to
Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings
For
with
the
this
court.
court are in the court record. That does not mean they're evidence, sir. And I told you
That's
that
not what I'm
previously.
asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
I think you just said
So
oath
they were
correctly.
filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told
Mr.
me,
Brooks, I am bringing this jury
Your Honor,
out.
with
Listen
all
to
respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr.
may I
Brooks,
give an offer into evidence?
I'm going to stop
these
you
things.
once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It
We
should
are
not
now
be, though,
at the
Your Honor.
jury. I understand your lack of consent, your
So
objection
when would I
is
be able to
noted
put?
for the
When would
record.
I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I
I'm going to
asked
do the
before
following,
yesterday,
sir.
Your Honor.
I'm
I
going to do
asked
the
this before
following.
yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying
of
to
the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the record
I am
does
going
not.
to take
It
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you, there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum.
Well, then
courtesy.
just hold me in
You-
contempt, then, Your Honor.
You are
Hold me in
hereby
contempt because
advised
I didn't even. I'm trying
that
to
if
seek
you
to
start
understand.
talking about subject matter jurisdiction or any of these other
It
issues,
needs to be addressed,
or
Your
in
Honor.
any way
We're not talking
interrupt
about subject matter
the
jurisdiction. We're
reading of
talking
the jury
about why
instructions,
my due process
I
has been
will excuse
violated.
the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment,
Right.
Section
I am
1.
taking a 5-minute break. We are
Your
in
Honor,
recess.
I don't
When
agree
come
to a
back out, the
estoppel.
jury
I
will be
don't agree
coming
to
as
a
well.
estoppel. Your Honor.
I love it when they mute him like that when he's in the middle of saying something. He don't agree to an estoppel. I think they want to shove that estoppel, where the sun don't shine. Okay, so just to check in with you guys, I've been in the background making sure we're not missing anything. If they show this, we will be there. There is no guarantee they'll show this. And all we can do is be at the court's mercy as to whether or not they give us a view of what's going on. So please don't send me any hate. If we don't see it, no one else is going to see it. So there you go. All right, let's get back to this. Fast forward. Where's his shot? They got to turn them chocolates on. You know that Bryce Rhodes guys, he got chocolates. How come DP didn't get chocolates? Maybe they don't have chocolates in Waukesha. They needed to. They needed to. Oh, by the way, you guys, if you're new to here and you've never been to my channel before, I have a huge playlist on the Waukesha Parade. So from trial to background information to all kinds of background on Brooks and the investigation. So please go check that out.
It has yet to be proven for the record. And upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it
Are
further.
you going to honor your oath of office?
All rise.
So I'll take that as a tacit agreement that you're not going to honor your
All
oath
right,
of
I'm
office.
going to have to excuse the jury.
Well, it is close to the end of the trial. He actually said tacit correctly this time. So he's starting to learn his words now that we're, basically the trial's over.
Mr. Brooks, I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present. In this, you can promise me right now, you'll respect prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks, I very expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to me that when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet, sir?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have
All
I
right,
acted
he
in dishonor?
refuses to answer the
Have
questions.
I acted in
I have
dishonor,
given
Your
him
Honor?
an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor,
Thank you.
have I acted in dishonor?
Okay, how many times did he say dishonor? Who counted? when I first did my channel, when I first set up my channel before I knew that I had to do the commentary, I had a great dishonor video. It was great. It had background music and everything. And I think I deleted it by accident. I have to redo that. Oh, he's horrible. He's absolutely horrible. Ridiculous. All right, just still got to let you guys know I have looked and checked and refreshed and checking on the court's website as far as the docket goes. I've also been refreshing the screen for the Zoom, and it does not look like they're going to be showing it today. If they are, now I will say this: every time that we've ever watched it that they did show it, they were way late in starting. Because this type of stuff gets pushed back when they're waiting on him to get pulled into the Zoom room, because he's probably going to be there via Zoom. They're not going to bring him over for something this small. All they're doing is assigning the new attorney. So it may be that they don't find that important enough. I kind of want to know what he looks like right now, because he's been in there a minute, and I want to see if he's gained any weight. We know that he's been in solitary confinement in a sense, or what are they, protective custody, whatever they call that. All right, let me fast forward through this.
Mr. Brooks in front of the jury. This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come
Excuse
back.
me. He
That,
says,
of course,
excuse me,
is
I gotta go
always,
pee.
something that I will give him. As soon as I make my full findings, I will pause and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made this morning to remove him is based on the authority from Illinois versus Allen. I'd also note that State versus Anthony talks about the Allen decision along with State versus Vaughn. Those are two state court decisions. Clearly, even though Mr. Brooks was using a mild-mannered tone of voice, he directly disobeyed the court order that he not interrupt once the jury was brought out. He did that immediately upon the first juror walking in. I believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that should he interrupt during the jury instruction phase of this trial by either objecting or raising issues that have no bearing on the advisement to the jury by this court of all of the jury instructions, I will consider admonishing him in the presence of the jury or simply removing the jury so that then I can admonish him and then making the appropriate record. All right, with that, since he's asking to come back, we will take a pause. We'll recess. We'll come back in when he is set up in this courtroom. Thank you, everyone.
Hey, we have 333 people watching live. I appreciate you being here. Please, if you do not mind, hit that like button for me. I would appreciate it so much. It helps me with my channel to get out there, to let people know that there's some of us that are still addicted to this dumb convict and his antics. Yeah, the new attorney was assigned on December the 1st. And today's court appearance is all about just putting it on the record that he's been assigned. And I thought I saw something he was asking for. I can't remember what I saw. I thought I saw something where he was asking for. No, I think that was the Sarah Boone case. I'm mixing him up with Suitcase Sarah. My bad. Which Suitcase Sarah should be a crazy trial. Hopefully I'm going to be able to follow that one if they allow us. Aw, hey, Barbara. Welcome in, glorious love. Welcome into part of the Hee Hee and the Kiki Kian Club, also known as Brooksaholics Anonymous. We have meetings weekly. After 1 year, you don't get a chip. You get subject matter jurisdiction. Maybe, I don't know. Whew. All right, let's fast forward this. Still no updates, you guys. There's been nothing on the court site yet. He's so flustered. He's nervous because he knows the jury's coming in.
Thank you, everyone. Please be seated. I'll have the jury brought out then. Record to reflect, we are all back in this courtroom.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before
Absolutely
the jury's
not.
brought out,
Absolutely not.
is that a tacit agreement that you don't have to answer those questions as a public servant, Your Honor? So are you going to act in dishonor?
Mr. Brooks,
Are you going to act in
I've already
dishonor?
addressed your requests.
It hasn't been proven for the record, Your Honor. It
The
should
jury
be.
is on its way,
They're not out yet, though.
but
Yeah.
they're on the
You
way.
held me in
I'm
contempt.
not
You held me in
addressing these
contempt
matters,
before-
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in
you're
any
back
way?
in this courtroom at your request. The jury is coming
I
out.
never should have
Please
been.
be respectful of their time
I
and of
have.
this
I have
process
been. They weren't
and
even
the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks.
before they came out.
You're
Have I-
just
am I
attempting
acting
to
in
disrupt the
dishonor?
proceedings.
Am I acting in dishonor? So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right, the jury.
Perpetual child.
No
is
jury's
not
out.
Mr. Brooks.
No jury's
close the
out.
door.
I was trying to
Mr.
address
Brooks,
this
they are
before they
right
came out.
outside this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out. And if you
and you're
say
making
one word when that door
you're
opens,
making a tacit
then
agreement.
you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're gonna hold me in
All right.
contempt?
The jury cannot come in. Never mind.
Are you gonna hold
All
me in
right.
contempt?
Mr. Brooks is going to be removed. We're in recess until that.
How
can
am
be
I
accomplished.
acting in dishonor?
At this point, it's almost like he's just what's the word I'm looking for, you guys? It's more than condescending. And the way he's doing it, his little antics today, it's like you know he's not really trying. You know he really doesn't mean what he's saying. He's just trying to be annoying. Unseen. Unseelie Hearts said, I'm a former teacher and I've taught little demons like Brooks before. That's why I'm so mad at Dawn. She has enabled him to be like this. Yeah, a lot of people say that. It's all about the upbringing. Well, you know. His daddy was a convict too. They say his daddy was the one that got in trouble for calling in some kind of threat in Las Vegas. And I wonder if Brooks went to Las Vegas looking for his dad, or if his dad was already in prison at that point. But I kind of wondered why he always went to Las Vegas. There's no telling. Oh, here, let me show you guys something while you're here today. I might have to take that off to show you guys. Yeah, I got to take that off to show you guys this. But look at this. In case you have not seen it, this is his fan club. And this was on his Twitter page on December 4th of 2015. He said, "Me and some fans." That's what it says, "Me and some fans." Now, if you look down at the bottom, you'll see that since December 4th of 2014, when he posted it, there's no likes. So apparently only one of his fans in the photo liked the photo that he put up. Or, you know what? He probably liked it himself. I would say that. I would say he liked it himself. We also have these great videos of him during his productions of his rap music videos. Oh my God, it's disgusting. It's so disgusting. So disgusting. All right, let's carry on.
And the United States Supreme Court indicated it is essential to the proper administration of the criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least three constitutionally permissible ways for a trial judge to handle such a defendant, including 1, bind and gag him, thereby keeping him present; 2, cite him for contempt; or 3, take him out of the courtroom until he promises to conduct himself properly. I understand Mr. Brooks is waving to the court. I'll address that momentarily. But the bottom line is there is a history of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note at no time during this case has jurisdiction ever been challenged when he was represented by an attorney. So I warned him, given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions. I will unmute him so that he can indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Can y'all hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making dispiriting remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful. For the record. And again, I'm trying to figure out, how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother. How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was done by the prosecution. I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am going to bring the jury out, Mr. Brooks. If you want to come back into this courtroom, you need to write your request down on a piece of paper. And when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom. Anything the state wants to put on the record?
I have a question, Your Honor. I don't have anything directly in response to Mr. Brooks' last statement.
All right, go ahead.
Yesterday afternoon, when we had the 4 screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do
Yes,
again?
it is. We can take the witness stand camera and pull it out so that he has a view of the jury box as well. I can't angle it, but I can
Yeah.
do that.
And for the record, when you do that, then he can see the jury box. So I would ask that that be done before
Right,
we.
please do that, Madam Clerk.
All right, we got an update on the docket. Let's see what it says. 12:14 status conference. Defendant Darrell Edward Brooks Jr. in custody. Attorney Russell J. Jones in court for Darrell Edward Brooks Jr. Prosecuting attorney Matthew James Torbenson and Michael Grasso in court for the state of Wisconsin. Case in court for status of counsel. Attorney Russell Jones is now the attorney of record. Case is adjourned to January the 18th, 2024 at 9 a.m. for status conference. Another status conference. So January the 18th, guys. Ugh. I just knew it was going to be the trial. I just knew we were going to hear about the trial. All right, let me change my date. I got to change my date on my live stream. So did everybody get that? Yeah, it's on the docket sheet. That was just updated on the docket. So they've already been in and done their thing. So there will be no viewing today unless a media outlet was there and captured it. They did not show it on their Zoom to the public. So at least we tried. If you want to guys continue to watching, please stay. Please stay. Let's continue to watch this, the verdict watch day, which is day 14 according to Law and Crime.
Well, it's not on Zoom, and so the court TV would be able to fix the camera on me and not on the screen, so that they don't capture any of the jurors, and they're directed to honor that and do that. Same thing, obviously, with our still photographer. If there are any images captured of Mr. Brooks, as you can see, the camera is being zoomed out. You would need to avoid capturing members of the jury.
Thank you, Your Honor. The record should reflect you have zoomed out the camera, and it looks
Right.
like about 90% of the jury box can now be seen in the view if Mr. Brooks chooses to do
Right.
that.
Mr. Brooks, I'll unmute. What is it you would like the court to address?
How can you rule that I don't have the right to be present in the courtroom?
I've answered that previously. I've made my findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself. And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.
Sorry, I'm typing this update on the banner to let us know that when we're going to be in there. January 18th. So people don't come on and go, what's going on? What's wrong? What's going on? Hang on. Because y'all know y'all do that. You know you do. All right. Where's the banner I just created? Hang on. Fast forward. If I had been the judge, I would have, like, every time they had to move and, like, she had to go to her quarters or whatever, I'd have been doing shots. I'm just saying, that's why I'm not a judge. But, some people would have been doing that. It's coming back on. Just give it a minute, please. Hold, please. That's the other one. I just created a banner and now it's gone. For January the 18th at 9 a.m. I gotta write that in my calendar.
Just have a time. Yes. All right, we are back on the record. Appearances are as they were before at 9:45. Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second to be present at my trial. I never consented to not being present, nor did I act in dishonor because he has not made a pledge to conform his conduct as is required under Illinois versus Allen.
Allen.
He has not reclaimed his right to be present, and we will continue with him in the other room. I will also make a finding today, and I didn't do this previously, although he's forfeited his right to be present, given the technology, the audio and visual equipment that we have, the fact that we've also backed out the one camera so he can see the jurors. I'll make a finding, even without that, though, that it's the functional equivalent of being present in this courtroom. All right, with that, then the jury will be brought out. I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request, I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions until such time he will remain in that courtroom. All right, go ahead.
Oh, and by the way, for those of you wondering, this is not box fort day. That was day 13. That was also when he was wearing his yellow shirt. No, not the actual trial. They're doing, Lenny, they're doing another status hearing on January 18th. Probably, as horrible as this sounds, but probably because the new attorney has to catch up. You would think he would have already done that, but so they're giving him time to get on board and catch up and do what he's got to do. Isn't that crazy? Well, I think that the reason they're going to do that trial, or they're going to go forward with that hearing, is because, I mean, every victim deserves justice. So that's part of it. Did he have the same red shirt on when you saw him in the mall? Yeah. She was his victim for what, 15 plus years? Now, they weren't together all that entire time, but yeah, he had her under his thumb. And it's hard to judge it if you've never been there. So he started grooming her when she was only 14 years old. She was very impressionable. Impressionable? That's the word I'm trying to say. All right, jurors are in the courtroom. Did you put the filings on the record?
Thank you, everyone. Please be seated. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Hospital with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present with respect to that count. 1. As to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's act was a substantial factor in producing the death. 2. As to each count, the defendant acted with intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 1, you should find the defendant guilty of first-degree intentional homicide as charged in count 1. If you are not so satisfied, you must find the defendant not guilty as to count 1. If you find the defendant guilty of count 1, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 2, you should find the defendant guilty of first-degree intentional homicide as charged in count 2. If you are not so satisfied, you must find the defendant not guilty as to count 2. If you find the defendant guilty of count 2, you must answer the following question.
You guys, you kind of think if you were a juror on this, I think really the only question that you would have is, did the brakes work? They did? Okay, why didn't he stop? I mean, any reasonable person, right? Did the brakes work? No, yeah, they did. They proved on the record that the car was fine. There were no recalls that would have affected it. The brake lights were on. He was braking at times to slow down from hitting vehicles or whatever when he was swerving. So, y'all hear Frankie snoring? My dog, my big pit bull is snoring. So yeah, if I was a juror, I guess that would be the only thing on my mind, really.
Yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 3, you should find the defendant guilty of first-degree intentional homicide as charged in count 3. If you are not so satisfied, you must find the defendant not guilty as to count 3. If you find the defendant guilty of count 3, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 4, you should find the defendant guilty of first-degree intentional homicide as charged in count 4. If you are not so satisfied, you must find the defendant not guilty as to count 4. If you find the defendant guilty of count 4, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 5, you should find the defendant guilty of first-degree intentional homicide as charged in count 5. If you are not so satisfied, you must find the defendant not guilty as to count 5. If you find the defendant guilty of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The 7th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 8th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 9th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 9.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 12th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoy under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 13th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Aiden Lofgren under circumstances which show utter disregard for human life.
There are a couple of people in the chat asking about the hearing status. So they did have the hearing this morning. They did not show it to the public, but I do have the update on there. They basically just assigned him a new attorney, which is Russell J.A. Jones, and they set another status hearing, which should be the last one. Let's pray and hope, for January the 18th. So we were not able to see anything that happened this morning. Once again, the court did not show it, and I've not found a media outlet that was there taping it either. So I appreciate you guys for coming in, but you are more than welcome to stick around as we watch Verdict Watch Day in the Waukesha trial.
Life while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, 939.63 sub 1 sub B of the Wisconsin statutes. The 14th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Theo Mazza under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 15th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tyler Pudliner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 16th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Connor Tank under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 17th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did reckless the safety of Eric Teagues under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 18th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia Mathioli under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 19th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 20th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Josh Craner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 21st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Riley Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
You guys want me
The
to
22nd
speed it
count of
up?
The information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Caden Rogers under circumstances which show utter
Speed it up
disregard
a little
for human
bit.
life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 23rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tucker Sparks under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 24th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isabella Bartelt under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 25th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yaretzi Becerra Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 26th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Samantha Coelho under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 27th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Madison Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 28th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mackenzie Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 29th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kathleen Pielmeyer under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 31st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Julia Schleichow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 32nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Olivia Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 33rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jennifer Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 34th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did directly endanger the safety of Jesselyn Torres under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Alice Darrell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 36th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charlotte Darrell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 37th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Vivian Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case,
He's only on third.
Brooks, on or about
All right,
Sunday,
I'll fast
21,
forward it.
2021, on Main Street, Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola bodily injury. 3, as to each count, the circumstances
Then she took a break.
part of the record, but I'm going to deny his request to make a further record for appeal.
Oh, wait, hang on.
as I need to continue advising the jury.
Let's see what she said to him.
All right, we are back on the record. The jury has not been brought out just yet. I indicated I would address the note that was passed by Mr. Brooks to the court. In it, he indicates the following: I have reclaimed my rights, parenthesis, that I never gave up or consented to give up, parenthesis, to be present, and you have not honored your oath of office to protect my constitutional rights, specifically my 14th Amendment, Section 1, which references equal protection of the laws. Would you like to explain this on the record, or should I will. If you won't, I would like to make an offer of proof for my appeal on the record. I indicated previously that should Mr. Brooks want to come back into this courtroom pursuant to Illinois versus Allen, he could certainly reclaim the right to be present, but he would need to be willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I specifically advise that he would need to pledge to not interrupt the proceedings. He has not done that, meaning he has not indicated he wants to come back or that he will pledge to be courteous and follow the rules of decorum, and specifically pledge to not interrupt as I read through the jury instructions. And his letters or notes that he passed will, of course, be made part of the record, but I'm going to deny his request to make a further record for appeal, as I need to continue advising the jury of the jury instructions. So with that, Mr. Brooks will remain where he is at. Anything further he wants to address, he will need to do that in writing, as he has done with a note, but I don't feel the need to give him any additional opportunity to explain that. What I will ask is he going to make a request to come back into this courtroom? And if that is true, he can give me a thumbs up sign, and then I will address that. All right, I will unmute him. Mr. Brooks, what is your request as it relates to coming back into this courtroom?
I've requested to come back into the courtroom with the first writing that you said I had to write.
I put that on the record already, sir. You did not pledge to respect the rules of courtesy and decorum and pledge to not interrupt the court. Are you willing to pledge that at this time?
Your Honor, with all due respect, I've never had to do that before to reclaim my right. I've always asked, when you've given me the opportunity, when I felt that the time was right, I've always asked to come back. Have I not?
Mr. Brooks, given your conduct this morning and your blatant violation of my direct order to you to not interrupt when the jury was being brought out, I felt it important to strictly enforce the language of Illinois versus Allen, and only bring you back if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, and specifically pledge to not interrupt as I go through all of these jury instructions. If you're willing to do that, I will bring you back in.
Your Honor, with all due respect, can we at least be fair and say today hasn't been as volatile as other days, or as the back and forth between you and I hasn't been
Oh my goodness.
what it has been previously.
Are you
Mr. Brooks,
serious?
we started the advisement to the jury an hour later than I anticipated, so I would thoroughly disagree with you. It might not have been volatile or loud, but it was nonetheless disruptive. So I will ask you these questions, sir. If you come back into this courtroom, are you willing to honor my request and order to you that you not interrupt as I read through the jury instructions?
Your Honor, I don't understand the question that you're asking.
Sir, are you
reason
willing
why-
to refrain from raising the issue of subject matter jurisdiction if you come back into this courtroom?
Your Honor, with all due respect to your ruling on Illinois versus Allen, that was not part of Illinois versus Allen. I don't understand why that's being
Mr. Brooks,
made
I'm not
on-
going to debate the meaning of Illinois versus Illinois v. Allen with you. I'm simply trying to get you back into this courtroom. You seem to want to be here, but you don't want to pledge to follow the rules of courtesy and decorum. So that's on you.
Your Honor, this has never been done before. It's never been done before, and I've always been able to reclaim my right to be able to be present.
Are you willing?
Which is what I stated when I first came over here. I've been stating the same thing. I've actually told the bailiff numerous times.
Mr. Brooks, I am strictly enforcing the language of Illinois versus Allen, which says the following. I will repeat myself again. Once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I have not required the pledge previously. I've allowed you to come back, but given the interruptions this morning and your immediate discussion of things like subject matter jurisdiction and my oath the minute one juror walked through that door, I cannot take that. I will not bring you back in without that pledge.
So where does it say anything about a pledge, Your Honor?
Sir, I'm not going to debate the language with you. I am establishing what I believe is a reasonable restriction on your right to come back into this courtroom based upon the history in this case of your repeated violations of the simple rules of courtesy and decorum and your failure to follow my very clear and direct requirement this morning that you not interrupt the reading of the jury instructions and you be silent once the jury entered the courtroom. I did that in part because it not only preserves the dignity and decorum of this trial, it also frankly protects your rights and it minimizes your bad behavior in front of the jury.
Thank you so much, Carol Austin.
I didn't interrupt you while you were talking.
So kind of you.
I'll let you make your record without talking over you or interrupting.
Thank you. I would agree with you just now.
The way that I'm interpreting, when you reference to me, with the Illinois versus Allen, where your ruling is coming from, the way that I interpret that is not the way that you're saying it to me now. That's why I don't understand what you're asking. I'm interpreting that in a totally different way.
I'd refer you to the third section of Illinois versus Allen, where the U.S. Supreme Court was discussing what the trial court did in that case. And it said the following: the trial court in this case decided under the circumstances to remove the defendant from the courtroom and to continue his trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom. As we have said earlier, we find nothing unconstitutional about this procedure. So that is the authority, sir, in addition to the other quotation. I'll tell you this. I'll give you one more opportunity, sir. You can come back into this courtroom, but I do not want you to address or attempt to address subject matter jurisdiction or any of the other rulings that I've previously made. I need to continue with the advisement to this jury about the rules that govern their deliberations. That is the stage we are at. And if you violate that in any way by raising any of those legal issues in their presence, that will be in direct violation of the requirement for you to reclaim your right, and you will be removed back to the other courtroom. Did you hear me say that, sir?
I'm informed, but Your Honor, now you just stated on the record if I raise these issues in their presence, but if they're not in the courtroom, it's not in their presence, correct?
Sir, I can't bring them into the courtroom until you're here. I expect you during that short interval not to raise these legal issues that I've already addressed multiple times. So yes, I'm telling you, if you come back into this courtroom, I don't even want to have you raise any of those issues. I want to bring the jury right out without interruption. That is my clear expectation, whether the jury's in the courtroom or not.
Your Honor, I'm confused because you just said don't raise any issues in their presence, and now I'm confused.
Because you're indicating to me by your statement that you intend to raise them once you get back into this courtroom. And so I'm making that another restriction, and you need to pledge to me that you will not do that.
Your Honor, the way that I'm interpreting what you just read to me from the other section that you just read from Illinois v. Allen, it does not have that language. So I'm
Mr. Brooks, I'm not going to debate the language. Do you want to come back in here or not?
I've stated numerous times that I shouldn't even have been brought over here anyway, that I wanted to come back. But now what I don't understand about it, Your Honor, is that there's being rules enforced.
Mr. Brooks, do you want to come back in here or not? It's a very simple question.
I said yes already.
All right, then I'm going,
say the same thing?
Because then you go on and make other statements, and then I can't even effectuate your request.
But I'm trying to tell you how I'm interpreting what you're saying to me. If you want
Mr. Brooks, I'm going to mute you. We're going to go in recess. He can be brought back over, but I will advise you that if you start back in, even outside the presence of this jury, with any of the legal issues I've already ruled on, you will go back to the other courtroom. It's that simple. So we'll be in recess. He'll be brought back over, and then we'll start back up.
Oh my goodness. Look, he's still talking. I love it when he talks when he's muted. And everybody always says, can we get the transcripts of what he was saying? You think we'll ever get to see those court transcripts? I put a request in. I did get some good stuff from the Waukesha PD, but I don't know. He's so exhausting. He is exhausting. I babysat a kid one time that was like that. Of course, the child was only 2. So there you go. Okay, let's see. Fast forward. I think we need to fast forward through these readings, though, you guys, because she's reading all the counts, and there's 70-something of them.
To this court, not an ambiguous one.
And that's a lot of the same thing over and over again. It's so hard to get this just right.
Consistently with the dignity and decorum that these proceedings deserve, and that includes not interrupting or bringing up legal matters that this court has previously ruled on. We have lost a significant amount of time now addressing, or not even addressing, but Mr. Brooks really interrupting the flow and the proceedings based upon his responses, and then he attempts to engage with this court on the meaning, for example, of Illinois versus Allen. He needs to make a very clear statement to this court, not an ambiguous one, but a very clear one, that he wants to come back into this courtroom and that he's willing to conduct himself appropriately. And until he does that, he will continue to forfeit his right to be present in this courtroom as I instruct the jury. So with that, I did give him 5 minutes. I said, you have 5 minutes to decide. I set a timer. It went off. He is still in the other courtroom. We are going to continue. So the jury is to be brought out.
And they can hear us fine.
And Madam Clerk confirmed that the audio and video is working just fine. I should further indicate he continues to be muted, so as there are not interruptions. And if he wants to address something with the court, he needs to put it, write it on his pad of paper, and I will address it at the appropriate time. Did the jurors go out?
Yeah, they won't give out.
11:01, I took the break. It's now 11:48. So I intended to take 10, 15 minutes tops. And Mr. Brooks, you can write it down. I'm not going to interrupt further. The jury's coming out.
She's pissed. Yeah, they don't have the phone calls. They may release something. I'm thinking they might release something after Erica's trial for the phone calls in relation to that case, but they didn't have any on record. Milwaukee said that they disposed of them after 6 months, but then I think that the jail phone calls are definitely part of the trial case because of the fact that they said that he was intimidating a witness. So I have put in a request for that. We'll see. We might even hear him in the trial.
Thank you, everyone. Please be seated. Continuing on then with the jury instructions. If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 48, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 48. If you are not so satisfied,
Y'all
you
look
must
at
find
him.
the defendant not guilty as to count 48.
Look at this fool.
Is not only that the defendant committed the crimes of hit and run, but also that the accident resulted in the death to a person. If you find the defendant guilty of a count of hit and run, you must answer the following question, yes or no. Did the accident involve death to a person? Before you may answer yes, you must be satisfied beyond a reasonable doubt that the answer to that question is yes. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as the count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Virginia Sorensen? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 69, you should find the defendant guilty of hit and run as charged in count 69. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Leanna Owen? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 70, you should find the defendant guilty of hit and run as charged in count 70. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Tamara Durand? And I will specifically address Mr. Brooks at a later point. Count 71. If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jane Kulik? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 72, you should find the defendant guilty of hit and run as charged in count 72. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Wilhelm Hospital? If you are satisfied beyond a reasonable doubt that all four elements of hit and run have been proved as to count 73, you should find the defendant guilty of hit and run as charged in count 73. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks? The defendant is charged with two separate counts of bail jumping. The 74th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Section 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. The 75th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Sections 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in Section
Such an
946.49
idiot.
sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of the bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on, bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of his bond. This requires that the defendant had the mental purpose to fail to comply with the terms of his bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run, resulting in death, and battery. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, or battery. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definition here. Battery will be defined in just a bit, and you should apply that definition here as well. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. The 76th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, near Frame Park in the city of Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that person without that person's consent, contrary to section 940.19 sub 1, 939.51 sub 3 sub A, and 968.075 sub 1 sub A of the Wisconsin statutes. Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1, the defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2, the defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3, the defendant caused bodily harm without the consent of Erica Patterson. 4, the defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all four elements of battery have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. I want to go back to the bail jumping because the battery is not part of that charge. And there's an inclusion of that in the jury instruction that I will have corrected. So I'm going to read the definition, the substantive instruction on bail jumping once again, starting with what the charges are. Well, the charges I've already read, they will stand. So bail jumping, as defined in section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of the bond. This requires that the defendant had the mental purpose to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, or hit and run resulting in death. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definitions here. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. An information is nothing more than a written formal against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. At times, Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any way. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by the witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider the witness's opportunity for observation, how long the observation lasted, how close the witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear the events, and any other circumstances of the observation. You should also consider the period of time which elapsed between the witness's observation and the identification of the defendant and any intervening event which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe deserves under all of the circumstances.
She's almost done, you guys.
An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received as evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of parties, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence.
I need a refill,
Disregard
Dolly.
entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of any other witness, than that of another witness or even of several other witnesses. Remarks of the parties are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility. That is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. It has been received that 2 of the witnesses in this trial have been convicted of a crime. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. At this time, I will reserve the instruction on closing arguments because we are going to take our lunch break and then come back after the lunch hour for closing arguments. All rise for the jury.
Whew, that was a lot. He's such an idiot. Let's see if he says anything to her. I don't think she lets him. No, they go off record. She needs a break after that one.
All right, thank you. Be seated. As soon as the doors close, I just need to put a couple things on the record. As I read, the doors closed, right? There we go. As I read through the bail jumping, it dawned on me that the battery should not be referenced because the battery was not on Main Street. And so I took it out because the way that the charge and the information reads, and we had that discussion preliminarily, which is why later on it doesn't reference the instruction for battery. So I cleaned that up by rereading it and taking that out. So I wanted to make a record of that. Obviously, I will need to have a new set made that has that correction. And I apologize for not catching that previously. But obviously I caught that as I read it. There's one other heading that said preliminary on, I think it was
You think his mind's spinning now? He's like, oh, I got to call her out on that.
instruction 70. I need to cross that out. And I think I found the word a or depending on how you say it, missing from one thing. I'm going to add that in, and I'll have that for the parties. And then I did note that at approximately 12:19, it may have been a little bit earlier than that, but I noticed Mr. Brooks was waving his hands. At one point, I did indicate I would address that at a later point in time. I am aware of a number of filings. I addressed two of them previously, but there are two additional. I am going to have copies made of all of these filings for the state so that they have an opportunity to review them. From my perspective, just briefly, he's making some objections to what I am doing, but at no time in those did he ask to be brought back to the courtroom. And certainly within those, he did not pledge to follow the basic tenets of courtesy and decorum. Given where I was at in the proceedings with the reading of the preliminary instructions and given the court's prior finding that he had forfeited his right to be present, I thought it important to get through the reading of the instructions up until the point of the closing argument instruction, which I reserve because I'll review that with the jury when they come back prior to the parties being given their opportunity to give closing arguments. I will also be advising Mr. Brooks that given that I'm moving on to a second part of this, that being the closing arguments, he will be invited back into the courtroom here for those closing arguments, of course, subject to his conduct. I expect that he will follow the rules of courtesy and decorum and also not raise legal issues in front of the jury.
She
when they are
expects a
here.
lot.
With that, we will take our lunch recess. It's 12:47. We'll take an hour and 15 minutes. Thank you, everyone.
All right, let's fast forward through. Yeah, so they were wrapping the trial up at this point. They haven't listed his verdict watch, but it sounds like Sue hasn't even given her closing yet. Now, we have watched Sue's closing before, but it was so good. It's worth watching again. I think they have it on mute right now. Let's see how long Let's count down. How long does he get to stay in the courtroom now? I don't think it's going to be long because if I recall, he was not in the courtroom when Sue did her closings. Am I right? I think so. Hey, Mike. No, Mike, we were on this morning waiting for the hearing that he had in Milwaukee. They ended up not showing the hearing in Milwaukee. And while we were waiting on it, we started watching day 14 of the Waukesha trial. And we're still on it. So we're enjoying it. So we decided to stay and watch. Oh, Kimmy. You're so sweet, Kimmy. Thank you. I know at one point I noticed that their sound was completely off. I think it was the early morning portion of this. I need a coffee. Where's my coffee, Dolly? I need a warm up. Carol said, good grief, the curse of Darrell. Just opened a bottle of Coke while in my recliner and it exploded all over me. Mm-hmm. He's everywhere. He's everywhere. Have you guys ever heard that Ray Stevens? Do y'all know who Ray Stevens is? He's a comedian, singer, kind of country singer. He was real popular back in the late 70s, I think. Anyway, he had a song called Santa Claus is Coming to Town or Watch Out, He's Watching You or something like that, talking about Santa Claus. And in the chorus line, he says, they're watching you. And there's this little high-pitched voice in the background going, he's everywhere. He's everywhere. Let's see. Yeah, we got you on our prayer list, Amanda, honey. I hope you're taking care of yourself. You like Ray Stevens, Julie? Yeah, he is so good. Remember the squirrel, the Mississippi squirrel? And then there was one called Don't Look, Margaret, or something like that. Was it the streaker or the in one of his things he says, "Are you naked?" He does comedy songs, you guys. It's really funny, but it's for the most part it is clean cut. It's like old school. And you'll have to look him up and listen to it. But anyway, there's one song where he says, "Are you naked?" And my uncle, y'all, he is a mess. To this day, when he calls me, that's the first thing that comes out of his mouth. "Are you naked?" So people that don't know it and understand it really kind of wonder. They're like, "That's your uncle?" I'm like, "Yeah, that's my uncle." He just really liked that song. The Streak. Okay, yeah. The Streak. Yeah, see, y'all know what I'm talking about. All right, what's taking so long? And why are we still on mute? Am I muted? Am I muted? Hang on, I'm going to go over there and speed it up a little bit. Oh, he's reading his sovereign citizen script on the ceiling again. Oh, God, here we go. Hang on. Of course, I sped it up too far. There we go.
All right, it's 2:00. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Good afternoon, Judge Sue Legacy and Zach, which I will bring to the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security, sesticue, trust action which you are a real party and interest to. As sui juris and propria persona. This is a military admiralty tribunal in maritime law under Title 4 of the United States Code, Section 1, which you can see, which states placing of fringe on the national flag is within discretion of president acting as commander-in-chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record to the extent that he raises objections or lack of consent is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is,
Of course you were.
it is not name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, what has yet to be proven on the record. May I receive those original copies timestamped?
All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee. And it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias. And so I do think it's important to advise the jury of that. I intend to do that when they come out. And then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, there is no magic way for you to evaluate the testimony. And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's.
I accept for value and return for value this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Certified.
I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all
I did-
respect, the state received copies. How come I can't receive the copies of my filings?
You know what? Well, I can give you the print offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you as the opposing party will have an opportunity to respond and argue. And then time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. The purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments, or the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper. under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Hopper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
It's gonna put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what I-
as,
yeah, I was gonna put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I made a ruling. The state has made a request. I granted it.
Yeah, but I'm
In terms
saying
of-
I don't understand what's being shown.
Are they
I have the
exhibits?
right to ask, to object and ask what it is that's actually going to be shown.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Ms. Brooks, I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up
Well, I guess it
exhibits?
depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is, once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and
I
ruling.
was specific, my other filings. That
That's
was
not
filed.
specific enough,
My-
sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
I want to smack him. You know she wants to smack
Are you
him.
done?
Sir, that's very rude and
I
disrespectful.
didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What
Your
filing
Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir. So when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How is it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
you
you
explain
are
why
not
that's
going
not
to
relevant?
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth and their duties and their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction.
So
to
they
you.
can't even know that I got a shock device on my ankles.
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
They don't want to know about your
Mr. Brooks,
chocolates.
Your custodial status is not on trial here.
I would
No,
argue that it
your
is.
conduct from November 21st of 2021 is
That
placed
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's
There
the thing:
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which
you
I
don't-
preserved my First Amendment right when I came in this morning, I also preserved my
All right,
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are.
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not.
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
your attention to closing instruction 460.
I'm
which will be
going
read
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't. No state law can override that.
Mr.
Any
Brooks,
law-
do you intend
any
to
law
keep this up when the
repugnant-
jury comes out?
Your Honor,
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before they come out.
Yet he's a
That's why I'm
sovereign.
trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform conduct to the rules of decorum, the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision. I looked it up earlier. I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand
Herring
for the
versus New
proposition
York?
that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting state Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record.
Oh, he let her. He let
With
her.
respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's
He is
the
not
chance for me to be
correct.
able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So,
not, I'm
I'm
not
not allowed to
required
make the
to give you
record
that
at all, Your Honor?
opportunity, sir.
I'm not allowed
Sir.
to make the record at all. As I just let you did, because some of the
Sir,
issues
I
has
have,
been some
you
of the
have
issues
told me
has
what
been
you want to do. I
Your
told
Honor.
you you can't. I've addressed the
Your Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing as
Mr.
far as
Brooks,
your ruling.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make
Your
an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue.
Contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings,
Your
whether
Honor,
he agrees with them
I
or
haven't
not.
dishonored the court. I'm merely
Oh, yes,
exercising
you
my
have.
rights under the Constitution, under the First Amendment, under the Sixth Amendment.
Mr. Brooks, your rights do not include disrupting these proceedings
I'm
the way
not
that you have through
disrupting
the
the
course
proceedings. You
of
just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you agree
present.
with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The record
satisfaction. It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you going to
follow the
answer
court's
questions as a public
requirements?
servant, or while you're making up laws that are not in the Illinois versus Allen? They never utilized
the
the
jury
mute button. They
can go
never
back
said
to the
anything
jury.
about a mute button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that not,
closing argument.
Your Honor?
You will
Can
be
you answer
taken
this
to the
question?
courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for
You
your
can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the courtroom
anything?
is to be cleared
Ugh,
so that Mr.
he
Brooks
is
can even move
dumb.
to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom, and I
and
can
you'll
do so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're
I think
trampling
she
over my-
did already. I think she did mute you lawfully. Well, even if it wasn't lawfully, she did, and we all enjoyed it. As Yaki said, the mute button was our favorite of the trial. Guys, we've been on for over 2.5 hours. Y'all know I have a time limit. I can't sit here like this that long. I got to get up and walk around. I got to stretch. We have a 7 p.m. live stream today to do our recipe exchange. So for those of you who have not emailed me your recipe, you better get on it. Because right now, I think I've only got patties. So we'll be back again on, I think tomorrow we're going to do the Halderson trial. We're going to try to get through that one a little bit. We're still seeing a lot of the discovery evidence in the Halderson trial. Tracy Ferreter and Tim Ferreter are also supposed to have a hearing tomorrow. I'm probably going to follow it. I mean, I might as well, right? It's just a hearing. And so that'll be tomorrow. And then on Saturday, if we have time, I'm probably going to do some more clips from this trial. In fact, what we'll probably do is just pick up right here where we left off and continue this day and continue watching it together. And as you guys know, on Sundays, it's the Sabbath. I don't do live streams on the Sundays. So I've got something in the works. Y'all are going to love it. I know y'all are. I'm not pulling it out yet, though. All right, guys. Well, listen, y'all have a beautiful evening. If I don't see you tonight on the recipe exchange, I hope I get to see you guys tomorrow. Take care of yourselves. Be good. Bye, everyone.